My name is Deacon, and I am a lawyer by training, but I've had a sort of circuitous career. I practiced for several years, and I've been involved in state and federal government at various levels, serving in an attorney general's office, serving in a governor's office, and then finally running the state health plan for the state of New Jersey for over 820,000 public sector lives, which was really the honor and privilege of a lifetime to do that for 3 years before needing to follow my moral compass, which took me in a different direction from working with the state. And I struck out on my own, starting what I'm doing now, which is consulting and working with employers directly, aligned purchasers and purchasing coalitions, and some nonprofits that are looking to change the world. I love the message of, and I'm so glad we just got to see that video again, because it reminds us of what we're here and why we're here. And it's to restore a market, right? And what does it take to have a market? It takes a willing buyer, a willing seller, and then that market clearing price where the X and the Y axis meet, right? But what do we have today? From a buyer's perspective, we have uninformed consumers. We have patients that are largely illiterate when it comes to healthcare, and purchasers often. We don't have, by and large, quality information. We have limited choice, and often no direct financial accountability. On the seller side, we often have coerced providers that are dealing with unfavorable network terms, no ability, contractual or otherwise, to differentiate their own quality of care from their peers, and limited market power because of consolidation, both horizontal and vertically. And then from a market clearing price perspective, right, where we have that, where the X and Y axis meet, we're completely sort of mismatched. And I think that was a word that somebody used earlier. You see these massive hospitals with their gleaming towers that are new, and their new proton beam therapy centers that they're building in every big city in America, and empty beds, right? And then you also have sort of my situation that I dealt with just recently. A couple months ago, I needed to get in to see a GP. This was February, and they gave me a June date. Thankfully, I found a DPC that, I was in sort of the next day. But we have really a mismatch of sort of the seller and the buyer side. We need more care and less hospital industry and PBN industry. But you are changing that, not just in small pockets anymore, but really at a macro level. And what we're going to talk about today is sort of the confluence of events, both from a litigation perspective and a legislative perspective, and public awareness, and this sort of confluence of events that's creating a moment and is really hopefully getting us closer to a future that we all envision. It's not going to be perfect. We're not going to agree on everything. There will be flaws. But as we all know, we can't let sort of the lack of ability to achieve perfection be the enemy of effort. So in the first bucket, we're going to talk about litigation. And I have to say, this part of the talk was, 2 months ago would have been fairly short. But just in that 2 months, 3 months, we've really exploded in terms of the litigation that we're seeing in this space, which it really makes the winds of change feel a little different. So there's 4 categories of litigation that are ongoing. There's employer versus carrier. There's employee versus employer. And then we have a case right now working its way through, which is the Department of Labor actually representing self-funded employers against a carrier. First, sort of the most mature line of cases is this employer versus carrier line of cases. We have one case that's been decided, which isn't so promising for some self-funded, and I'll just explain it briefly. So the Massachusetts Labor Union filed a suit against Blue Cross Blue Shield of Massachusetts. The factual allegations essentially were you were paying, higher than negotiated rates, higher than the rates you promised. You were paying duplicate payments. Basically, you were, really poorly managing our health spend. And Blue Cross Blue Shield of Massachusetts filed a motion to dismiss. And their arguments, and just to briefly pause, a motion to dismiss, what that means is they say, even if everything you're saying is true from a factual perspective, the case is still going to fail as a matter of law because you haven't established a legal claim. And in this case, they're saying, you haven't established that we owe you anything from a fiduciary perspective. And the court agreed with them. The district court agreed with them, and then the First Circuit agreed with them. It wasn't appealed to the Supreme Court, so this is now the law of the land in the First Circuit. But I wanted to read a quote from that First Circuit opinion that really demonstrates the lack of understanding at the judicial level of what we're dealing with. And this is the quote. Blue Cross Blue Shield of Massachusetts and AHIP persuasively argue that attributing fiduciary status to Blue Cross Blue Shield on this case's facts fear with Blue Cross's business model in a manner that could also harm plan participants and beneficiaries. If Blue Cross Blue Shield were required to adhere to strict fiduciary duties in the interest of individual plans, it would arguably need to restructure its networks and procedures based on the needs of each plan, undermining its ability to act in the overall best interests of its book of business. Such restructuring could ultimately come at a steep price to plans and their participants. That outcome could constitute an unnecessary upheaval in the TPA industry. So if we think that sometimes the judiciary gets it and they're on our side and they're going to get it right, I think this case really proves that that's not the case. But again, that's just the First Circuit, and it hasn't been appealed. It won't be appealed. So on to the next case. And the next case is the Bricklayers case versus Anthem and Empire. This is a class action, again, by a union that is taking on, as a class, Blue Cross Blue Shield and their overpayment of claims. Again, paying claims in error, paying claims not consistent with the negotiated rate that they were now seeing in some of these transparency files. And then an added element is they claimed that the carrier was preventing their access to data. And this is a huge issue, and it's an issue we need to deal with both at the federal level. This was also, they used the CAA. How many people know what the CAA is when I say that acronym? All right, great. For those of you who don't, the Consolidated Appropriations Act of 2021, otherwise known as the CAA, imposed some additional duties upon self-funded employers and ERISA employers that includes the fact that they cannot sign a contract that restricts their access to their own data. It puts the onus really on the employer. So anyway, the plaintiffs in this case said, Blue Cross Blue Shield isn't giving us our data. Therefore, they're breaching their fiduciary duty to us. And Anthem, very flippantly in their response, again, I'm going to read a quote because you can't make this up. If plaintiffs believe that they need to renegotiate their contracts with Anthem to meet their obligations under ERISA and CAA, they are free to do so. Plaintiffs cannot turn their quibble with Anthem and their rational restrictions on the release of data into a valid fiduciary breach claim under ERISA. Now, oral arguments are going to take place in that case on this motion to dismiss. I believe it's next week. It was filed in December of 2022, so the wheels of justice turn very, very slowly. But again, I think it really is going to be decided at the motion to dismiss stage. The next case that is, grabbed all the headlines is Kraft Heinz versus Aetna. Has anybody heard of the Kraft Heinz case versus Aetna? We had a few hands. Okay, so this is important because it's the first time we have a big corporation taking on a big corporate carrier. Kraft Heinz alleges that both that they paid claims in error and weren't being prudent fiduciaries, but also that they were breaching their fiduciary duty by not handing over claims data. Now, the case ultimately settled and went directly to arbitration, so we don't know the outcome. We won't know the outcome. It will be covered so deep under NDAs for I'm sure the reasons why Aetna wanted to keep it out of court. But it was, again, attention grabbing nonetheless, because again, for the first time, we had a large corporate entity willing to take on one of the big carriers. Now, interesting fact, the complaint was never actually served. And that fact was left out of all of the many news articles that case. It was likely a really strong arm negotiation tactic. The complaint was never actually served on Aetna, and I would find it hard to believe it's because they couldn't find Aetna. But a response was never due, a motion to dismiss was never filed because it was never actually served. So the next case and category of cases is the employee versus employer. Can anybody guess what case I'm talking about? Over there. That's right. So this is the Johnson & Johnson case. And if you haven't heard about it, this is an employee who is purporting to represent a class of her fellow employees at Johnson & Johnson, alleging that as an employer and a plan sponsor, Johnson & Johnson breached its fiduciary duty by hiring Express Scripts and overpaying for drugs, right? They used some pretty egregious examples in the complaint, a $10,000 drug on the formulary when they could have gotten it for, $30 or $50. They bring out some pretty egregious examples as to why they would say J&J was not prudently purchasing pharmacy benefits for their members. I don't think it's a mistake that this case, like the first test case, is against a pharmaceutical company, right? Because on the one hand, you have J&J as an employer, right, who is supposed to have a fiduciary obligation to the plan and plan participants to do what's best for that plan. But you also have J&J as a pharma company who actually benefits and profits from the status quo system that is harming them as a health plan and harming their plan members as patients. So they likely, and again, this is me guessing, educated guess, they likely had to do sort of that analysis of, do I become a disruptive purchaser and benefit my plan and plan participants pursuant to my fiduciary obligation on the one hand, or am I making enough off that really screwed up system as a pharmaceutical company that has to work with ESI? What does that math look like? Clearly, I think J&J didn't have an incentive to really disrupt how drugs are currently purchased and how PBMs work. So they stayed with the status quo and they were served with the complaint. And the case is ongoing. Now, the motion to dismiss in that case hasn't been filed yet. But interestingly, a very powerful law firm in New Jersey representing the defendants, which my husband thinks I'm crazy for taking on politically connected, powerful people in the state of New Jersey because we've watched The Sopranos. But nonetheless, this law firm filed a letter with the court essentially setting forth and sort of previewing their arguments. And their arguments, I think are just sort of beyond the pale. And again, really demonstrate the lack of understanding that sort of, whether it's the judiciary, these lawyers that are going to be arguing these cases, the lack of understanding that they have. Again, sort of best demonstrated by a quote. He states, because J&J bears the lion's share of plan costs, it is not plausible to infer that the defendant's process for selecting ESI was defective. On the contrary, J&J has every incentive to negotiate the best overall deal and plan pricing and services. So the obvious explanation for selecting ESI is that defendants got the best overall deal they could for the entire drug program. So taking that reasoning, every plan sponsor who bears the lion's share of the costs, in their words, because they have an incentive to lower costs on the surface, the only reasonable inference is that they are reasonably purchasing healthcare. And I just think that they get that so wrong, right? And we know that's wrong. So more to come on that case. I do think it's going to be one of the more important cases to come our way. The next case is the Department of Labor. The Department of Labor, they've focused a lot of mental health parity and QTL, and this is an interesting foray into what it means to be a fiduciary. They have filed a claim against Blue Cross Blue Shield of Minnesota on behalf of all the self-funded plans in the state. And the factual allegations are that Blue Cross Blue Shield of Minnesota essentially was duping the employers by adding on provider taxes to the claims. So, and not disclosing it to the employers. So these providers owed taxes based on the amount of the claim, provider taxes in the state. And rather than sort of work that into their cost and overhead, they said, hey, Blue Cross Blue Shield, can you just add that fee on and pass it on to the employers? And they struck a contract that said, yeah, we can do that. We'll just add that on, right? And we'll just pass it on through the claim file, and the employers will pay it. They probably won't know. And the employers did pay it, right? So the DOL comes in and says, you can't do that. Blue Cross Blue Shield's defense in their motion to dismiss was that I absolutely can do that. My contract with this provider says I can add those fees. I can add those taxes. And oftentimes these contracts say you could add value-based payments. You can add performance, pay for performance fees. You can add capitation fees. Blue Cross Blue Shield is saying, because I have an agreement with this provider to add these fees onto this claim, the purchaser has agreed to pay it. Because when they agreed to pay my negotiated rate, they agreed to the terms of that contract that they didn't see, that they're being held to. So it's going to be a really interesting case. And I think, I've been asked, well, why are they doing this, right? Blue Cross, does anybody have Blue Cross Blue Shield here? You don't have to raise your hand if you don't want to. It's okay. But you often see that Blue Cross Blue Shield, they have the best discounts, especially for public sector entities that have to go out to public bid. And so they win a lot of contracts, but then you get the experience back and it's like, God, we have a 6, 7, 10% claim trend. What's going on? Well, when they bid your business, they're only bidding on the price, right? They're bidding on the price net of the tax claim that they've tacked on, the capitation fee they tacked on, the pay for performance fee they tacked on. So you think you are getting this price and this great negotiated discount, when in fact, when you actually start paying the claims in the following year after awarding them your business, they have an agreement with the provider that they're just going to pile on, and you're never going to know about it. So that case is really important too. And more to come. We'll see how the motion to dismiss is decided. Finally, and this is why I can't do decks, because I would have to update them so frequently, like 24 hours before. We have a case with Mayo Clinic. We have an employee of Mayo who has filed a breach, not only a RISA claim, but a RICO case against Mayo Clinic as an employer, and then also Medica as the health plan for the employer. And the allegations are here that Mayo and Medica conspired through their provider search tool to lead people to go out of network so that Mayo and Medica could reimburse that out-of-network provider at a much lower rate, and then force the cost sharing and the balance bill on the member. So the example given, which I've actually experienced myself, is trying to find an adolescent psychiatrist in the US is pretty difficult, right? You go to your provider search tool, how many are in your 50-mile radius in network? Usually it's this, right? Because they don't need to be a network because there aren't enough of them and they can pretty much charge whatever they want. But this plan said that if we don't have providers in network, we will reimburse as if they were in network. And so they use the search tool, they go to the adolescent psychiatrist, and then they turn in the claim, the out-of-network claim, and they grossly underpay, and the member is now stuck with an exorbitant bill. And so this case is centered on really that fact pattern. The interesting piece that makes this, again, sort of different and unique is that Mayo is benefiting on both sides of the deal, right? Because not only are they underpaying and sort of screwing the out-of-network providers that have held out to not be purchased by Mayo or to not be in Mayo's network, which will now benefit them as a company and as a business, they're also winning on the insurance side, to the detriment of their members. So that's the universe of really important legal cases that are working their way through and that will have a tremendous impact, we hope, and I really do believe that they will, on sort of the future and where we're headed. From a legislative perspective, the list is a little bit shorter, thanks to Dr. Dickerson, who did the job of explaining the Texas law that allows insured folks to pay a cash rate. That's huge. We need to think about making that a reality in more states, not just Tennessee and Texas, and even a reality for self-funded plans. Right now, that's applicable only to fully insured regulated markets at the state level. We need that to happen at a national level, and that means we need to capture ERISA plans. There was some really important legislation that was working its way through at the federal level that would codify price transparency, strengthen price transparency at both the hospital level and the transparency and coverage level. However, we were ultimately unsuccessful in getting some of the language that we needed into a package that would ultimately get passed and be really meaningful for employers. We're going to get a second bite at the apple in the next funding bill in September. And then after that, we'll be able to hopefully push something through in lame duck. But the hospital lobby is strong. It's out there. They've already gutted the site neutrality provision of a law that passed, I think it was like 370 to 40. And still the hospital lobby came in after the passage of that law and gutted some really important pieces of it. But I think if anything, we can take the lobbies, they're paying attention to us and now they're fighting us, which means that we're sort of in that third stage of four. First they, and Dave's used this quote before from Gandhi, first they laugh at you, then they ignore you, then they fight you, and then hopefully we win, right? But it's not a foregone conclusion that we're going to win when, for example, pharma has 1,700 full-time lobbyists in Washington. That's 3 to 1 per congressman. And that's just one of the industries. And that's what we're up against. And that's why we need, folks like you to get involved in, at the state level, at the federal level. I've heard from multiple policymakers that the voice of one provider is worth the voice of 50 lobbyists. The voice of one patient is worth the voice of 50 lobbyists. So it is very important that your voices are heard because they do make a difference. So pulling it all together, what does this mean? You may have seen, I work with a group called Patients' Right Advocate, and you might have seen some of their more sort of national presence and campaigns and celebrities that have stepped up to talk about pricing transparency in healthcare, right? We have Jelly Roll, Fat Joe, Chuck D, Busta Rhymes, Foo Fighters, all stepping up to take on this cause because they know, and they've probably had family members that have been impacted by this broken system. Fat Joe told me 2 years, I never thought I would start a sentence like that. I've got to start. Fat Joe told me. Well, it's true. So Fat Joe told me that 2 years ago, when he and Cynthia Fisher, the founder of Patients' Right Advocate, went to Washington to talk about price transparency, hospital price transparency, they got one meeting. They got one meeting from one congressman that was willing to give them, 15 minutes to talk about this really important topic. This year, he had a full dance card. He had calls from the White House asking him to pop by and talk to Kamala Harris about hospital price transparency. And then he had a whole bunch of proxies, with people like me and Dave and others who brought voices of employers and providers to Washington to talk to congressmen about the importance of transparency in healthcare. So what that signals, right, is that the times are changing and we are in a moment. But it's really because, and only because, of people like you in this room that are putting in the hard work and actually doing the work of changing and not just talking about it. Change will only happen if we continue, and I think this, I'm gonna, if I could point out the med students in the room, because your role in this cannot be overstated. Change will only happen if we keep pushing on the door. We can't knock on the door politely. We can't ring the doorbell. We have to lean in and push through the door if we want to see, the future we all envision. And we're not going to all agree on everything. There are going to be certain, even amongst the folks in this room, the people that are aligned, we're not going to agree on what the future might look like completely. We're not going to agree on how we get there completely. But what we can all agree on is that the playing field needs to be leveled, and we need transparency to restore some semblance of what that market looks like, right? Which is what everyone here is sort of fighting for. And I love that, again, that we played the video, because it dawned on me, the Back to the Future theme it's just so poignant. I'm often asked, yeah, but how progressive can you be, or how, thinking about this healthcare of the future and the innovative model of DPC and APC. And I said, you know what? It kind of bothers me that we're thinking about this as innovative. To think that restoring the provider-patient relationship is innovative, right? It is sort of hearkening back to what it should be all about, restoring the patient-provider relationship. So in a way, it is sort of back to the future, because we want to be innovative in how we do things. But at the end of the day, it's about restoring a lot of what we've lost in medicine and healthcare. Thank you for listening, and thank you for all of the work that you do.